All right, so I'm going to start out. Now this is the 7th time I'm trying to record this video. And I'm going to start out with, let's just memorize what you have to know. And then if you want to keep listening, I'll post the attempted explanation of what the fuck this is talking about. So 202.48 is submission of orders, judgment, and decrees for signature. There's 3 time rules here, and then there's also a who and a what and a where. Okay, so let's start with the 3 time rules. The first one is 60 days. So 60 days after the decision is filed and signed by the judge, the lawyer that won has to draft a proposed judgment or order. So whenever you see proposed orders or judgments, 60 days. Okay? Then it says, failure to submit the order or judgment timely shall be deemed an abandonment of the motion or action unless for good cause shown. C, when settlement of an order is directed by the court, a copy of the proposed order or judgment with notice of the settlement, returnable at the office of the clerk of the court in which the judgment is granted, or before the judge if the court has so directed or the clerk is unavailable, shall be served on all parties either personal service not less than 5 before the date of settlement, and then counter orders of judgment is not less than 2 days before the settlement date. Now the reason you only have to remember those 3 time rules, 60 days, 5 days, and 2 days, is because the other 2 time rules are simply determined by adding 5 days for mailing. So by now, you should always know that other than a cross motion, it's always adding 5 days for mailing. No matter what you're serving, you have to add 5 days for mailing. That's why personal service, hand delivery, 5 days before the settlement date, counter order, 2 days hand delivery before the settlement date. 5 plus 5 equals 10. So if you mail the proposed order or judgment, you have to do it not less than 10 days before the settlement date. And same thing with the counter order or judgment. Have to add 5 days to the 2 days, which would give you 7 days. So let's read this all together. 60 days after the signing and filing to submit your proposed judgment or order. You have to serve it by personal service, not less than 5 days, by mail, not less than 10 days. Now, counter orders have to be not less than 2 days if you in-hand delivery by personal service, or by mail, not less than 7 days before the date of settlement. And then just note that any proposed counter order or judgment shall be submitted with a copy clearly marked to delineate each proposed change to the order or judgment to which objection is made. So if the proposed judgment is 7 pages, but you have only one issue on page 6, you have to actually let the court know right off the bat, my only issue here is right here on page 6. That's the only thing I object to. Now, it says, with the notice of settlement, it has to be made returnable at the office of the clerk of the court in which the order or judgment was granted, or before the judge if the court has so directed. Now, what they're saying here is not worded correctly, in my opinion, because what they're actually requiring is that you go to the clerk in the trial court, not the county clerk. So they shouldn't be saying the clerk of the court where the judgment was granted, because that's confusing. Anyway, memorize that phrase. It says returnable at the office of the clerk of the court where the judgment or order was granted, or before the judge if the judge so directed or the clerk is unavailable. That's what you're serving with the copy of the proposed order or judgment. You're serving a notice of settlement, and you're serving it on the other parties. And the time rules, again, is 5 and 2, but if you're mailing it, 10 and 7. Okay, there's the time rules and my sad little explanation. You may have absolutely no idea what the fuck this is talking about, and if you want to learn what it's talking about, you can continue listening. What is a proposed order or judgment? What's a notice of settlement? What does this thing mean when it says signing and filing of the decision directing the order be settled or submitted? Okay, well, this is what it all means. The example I'm going to use is called a motion for summary judgment. Using that for two reasons is because it's part of Article 32 of the CPLR, which is on your test. So you have to actually know what a motion for summary judgment is, what accelerated judgment actually means, because that covers an order, judgment, whatever. The difference between a regular order is it can be at any time during the case, the court can make an order. A judgment, however, resolves an action. A final judgment is what you appeal to the appellate division from. So a judgment is very different than a regular proposed order, but they're all lumped in here together, which is why I'm going to use a motion for summary judgment to explain this rule. So motion for an order and a judgment declaring that the issue raised is not one of fact. It's only an issue of law, and therefore no trial, no testimony is necessary. The court can actually make a final judgment based on all the papers alone. So all the papers that are submitted with the motion for summary judgment is what the court decides the entire case on. No trial. If an issue of fact is raised, a motion for summary judgment will fail. Okay? Be clear on that. There's an issue of fact that's raised, and the court agrees this is a disputed fact, cannot win a motion for summary judgment. So, what does this mean? It means that if the plaintiff is the one making a motion for summary judgment and the defendant raises an issue of fact successfully, yes, defendant wins. And defendant he's got to wait 60 days for the judge to sign and file their decision. So the judge makes their decision and says, I find defendant raised an issue of fact. Defendant, you're the winning party on this application, so you submit a proposed order which says motion for summary judgment has been denied, etc., etc. And you serve it on the other lawyer, the plaintiff's lawyer. That means the case keeps going forward. Okay? Now, what happens if the plaintiff wins their motion for summary judgment? The court has 60 days to make their decision saying, okay, plaintiff, you win. No issues of fact in this case. Plaintiff granted summary judgment. Plaintiff, submit your proposed judgment. The plaintiff has to then get 60 days to draft their proposed judgment, which will resolve the case. But either way, both times they're going to get 60 days. So the court is actually now not drafting, the court's law secretary is not the one drafting the final judgment or the order here in this rule. The court is directing the lawyers to do it. Now, what if the lawyers sneak something in that judgment? What if it's a 35-page judgment or 35-page order and they snuck something in there that the court didn't include in their decision? That's why notice of settlement is required with a copy of the proposed judgment. Has to be served on the other parties so that those other parties have an opportunity to take a look at the proposed judgment, read it over, make sure everything's kosher. If it's not, the other side can do a proposed counter order or proposed counter judgment saying, Your Honor, on page 6, plaintiff's lawyer stated blah, blah, blah. That shouldn't be in this judgment. Wasn't in your decision. And those get returnable for what we call settlement date, fake date, that the court is supposed to sign it. Now, in reality, does that ever happen? Nope. It's going to sit on the judge's desk until someone has a chance to review it. But whatever. It's a fake date that gives the other lawyer the minimum of 5 days to review the proposed judgment. That is what this rule is talking about. It's talking about when the court makes a decision, writes a decision, files it, signs their decision, and says to the lawyers, you lawyers, whoever won, you submit the final proposed order or the proposed judgment, and if I like it, I'll sign it. I don't want to make my court attorney draft it. That's all this is talking about. So just, you don't really have to understand it. I don't think for the question, you probably will not have to understand what this means. I would just memorize that it's 60 days after the signing and filing. That's when you have to submit it on notice. Failure to do so is deemed an abandonment. Know the word abandonment of the motion or action unless there's good cause. And then when it's directed by the court, you got to serve it at least 5 days before the fake settlement date by personal service or 10 days by mail. And if there's a counter judgment or order, that's got to be served by personal service not less than 2 days or by mail not less than 7 days before the date of settlement. So the time rules here, we got 60 days, 5 days, 2 days, or if everything's being done by mail, it would be 60 days, 10 days, 7 days. Do a quiz on this, little quiz question on this. It's going to be really short, and it's going to be fill in the blanks because you just have to know these time rules cold. If they give you this question with just the time rules in it, it is a gift. It's a gift. All you got to do is memorize 3 numbers and know, oh, mail. Okay, I got to add 5 days. Okay, literally just remember 60 days, 5 days, 2 days, and then if it says something about mail, oh shit, I got to add 5 days. So it's actually 10 days or 7 days.